I'd just like to table a document as foreshadowed by a witness on the 23rd of October, the Fair Work Building and Construction Director, who gave the committee his report as he promised on the 23rd of October last night. So just circulating and seeking for that to be tabled. There being no objection, thank you. I've just got a short statement.
You're saying no objection. You're actually seeking leave. I need to see a document if you're seeking leave.
Of course. Senator.
No idea. Just relate to the employment part of things.
Senator, on the 23rd of October, the Director foreshadowed as part of his estimates evidence that this was coming. It came in yesterday and we need to table it so that it can be put up on the committee website as part of our estimates proceedings.
So it's part of the employment estimates, not the education estimates.
It was his evidence, was it?
Yeah,
It's part of the employment estimates, not the education estimates.
No, not education estimates, but the committee's estimates, of which we're in additional hearings today. Thank you very much. That being noted by the committee, I have a short statement to read. I've read the report by the Director of Fair Work Building and Construction into the abandonment of litigation involving the Victorian desalination plant and also the mediation of other matters, the so-called cold cases, which occurred under his predecessor, Mr Lee Johns. In relation to the Victorian desalination plant litigation, Thies de Gaimont, CFMEU and others, it appears that despite there being sufficient evidence for the ABCC to independently proceed, and this being in the public interest on the basis of his reassessment of the matter, particularly his assessment of the Thies de Gaimont joint venture's lack of resolve to proceed, Mr Johns indicated to the CFMEU's National Secretary, Mr Dave Noonan, that he would not take over this proceeding nor commence his own proceeding. This led to the CFMEU settling with Thies de Gaimont. It appears that in seeking to settle the case with the joint ventures, the CFMEU wanted assurances that the regulator would also walk away. That is, the CFMEU was asking the ABCC to ignore its duties and the broader public interests for the private commercial interests of the CFMEU and the company. In relation to the global settlement of litigation outstanding when the FWBC took over from the ABCC, mainly against union respondents, largely against the CFMEU, it appears that the contraventions and penalties agreed upon did not bear a reasonable relationship to the CFMEU's offending conduct. All but 3 were at the lower end or below the assessed appropriate penalty, and individuals who had specific claims made against them were not held account for unlawful actions. I must say I'm shocked at the supine approach taken by Mr Johns to exercising his powers, which were the result of a deliberate, flawed and patently unsuccessful policy of appeasement of the CFMEU in, at best, naive belief that this would improve CFMEU behaviour. I'm also deeply disturbed by the cosy private dealings between Mr Johns and the CFMEU's National Secretary Dave Noonan outlined in the report tabled today, which gave rise to these outcomes, as well as the lack of transparency around these dealings. They had no effect on CFMEU behaviour, and if anything, in my view, this policy of appeasement encouraged the CFMEU to believe it had the measure of the regulator and could act with impunity. And its militant behaviour worsened, as we saw in the Grocon dispute, which occurred in the midst of these dealings. It's clear to me that in replacing the former ABCC with the Fair Work Building and Construction Inspectorate, the former Labor government created not just a toothless tiger, the charge at the time, but a pussycat which cuddled up to and was stroked by the CFMEU. In conclusion, I commend the changes being made to ensure that decisions are transparent and that the appropriate record keeping is maintained at a corporate rather than an individual level. Thank you.